Welcome back to Canadian Justice, where we're discussing a recent decision from the Supreme Court of Canada about whether or not refugees can claim asylum if they arrive to Canada through the United States. It's called the Safe Third Country case. Now, Eva, one of the questions I have is why these refugees were not claiming asylum when they were in the United States. If they arrived in Canada through the United States, why not make the claim there? And what type of risks were they saying they faced if they were to be returned to the US?
Okay, so this goes back to the non-refoulement, which is the court recognized as a principal obligation of international law when it comes to refugee claimants, and it's really that you can't return them to a country where they would face irreparable harm, including threats to their life, freedom, or torture, or any degrading treatment. And so, what they said that they would face if they were returned to the United States was solitary confinement, that the detention centers in the United States for immigration detainees were abnormally cold, that they were housed with other criminal defendants, that the medical care received by immigration detainees was inadequate, that the religious and dietary restrictions were not respected. And one of the principal reasons, or one of the points of commonality that the claimants had, was one of the reasons they could not claim refugee status in the United States is because in the United States, you have to make a claim for refugee status within a year of arrival. And some of these claimants had been in the United States for longer than a year. One had actually been a child there and grown up there and then could not return to her family. So there was this issue that if they because some of them hadn't made a claim, so there were problems in the United States. And then the second problem was because they were being returned to the United States where they hadn't filed a claim within a year, they would then be sent back to their country of origin where they alleged they would also face persecution that they were fleeing from. So there were the problems with the United States detention centers, and then the second issue was the potential return to their country of origin.
Now, Connor, both you and Eva were represented interveners in this case. One of the things that the court held was that designating the United States a safe third country does not violate the charter protected rights of these asylum seekers to life, liberty, and security of person protected under Section 7 of the charter. I want to get at a high level your reaction to that part of the decision.
Well, Christine, my reaction to the decision is mixed. I mean, on the one hand, despite the outcome, I actually think that some aspects of the decision are actually a win for charter rights. So the Federal Court of Appeal had actually tossed out the challenge on the basis that it wasn't properly constituted. It wasn't a proper charter challenge. And the Federal Court of Appeal essentially said, if you want to challenge something, you need to challenge the administrative actions under the legislative regime rather than the regulation itself. Now, the Supreme Court of Canada rejected that position and said that as long as there is a sufficient causal connection between the law and the alleged harm, you can challenge the law itself rather than the administrative action. And I think that's important because it allows charter claimants to go upstream and challenge the law that is resulting in potential charter deprivations rather than the downstream actions of administrative actors. I think that if there's room for criticism of the court's decision, it's that the court may not have sort of done a deep enough dive into how this regime actually works on the ground. A lot of the focus was on the availability of safety valves, and I think if there's one criticism of the court, it's that it didn't spend enough time on how do those safety valves actually work in practice on the ground. And that matters because laws don't apply in the air, right? They apply to real life situations on the ground.
Yeah, and I think, I mean, I'm not a fortune teller. I don't know what's going to happen in 2024. But if the fact scenario that led to this case being brought in 2017 was the Trump administration's executive direction to uh, the way immigration and asylum seekers were being treated, if that was part of the factual matrix, I think that there's at least maybe a 50% chance
Right.
that factual matrix will reemerge within a year. So I think that it's such an important point, Connor, that we need to emphasize, yes, that the facts on the ground matter, that law is not just this hypothetical in the air, it actually has real implications for people on the ground. Now, Eva, you also represented an intervener, the HIV/AIDS legal clinic in Ontario. When we come back from this break, I want your reaction to the decision.